by a misapprehension of the mandates of these two institutions. On the one hand, we have the Commission on Administrative Justice, which is a body created by an act of parliament or a statute. On the other, you have a constitutional commission charged with particular mandates, of which discipline, questions of conduct or misconduct regarding judges is domiciled in that institution called the Judicial Service Commission. But I think there is something that we have to read much more than the statutory underpinnings or any other undertones. For the first time, as my senior said, you have one commission, questioning another commission. And by the way, in my view, I think the Commission on Administrative Justice is an inferior body compared to the Judicial Service Commission. The Judicial Service Commission is a constitutional commission. The Commission on Administrative Justice is a statutory body. Okay? So that if one summons the other to be answerable to it, I think there is a constitutional conflict there. There is actually a serious constitutional conflict that has been raised by this issue of one commission summoning another commission. Yes, I do agree that we live in an era of accountability, constitutional accountability, where norms, rules, and institutions have to speak and are to govern our lives, our constitutional governance. But I think it must be within the black letter of the law, It is quite anomalous. It's actually quite strange that an inferior body can summon a superior body to go before it to answer particular questions of governance. And particularly the issue, the facts in issue here is a question to do with perhaps misconduct of judges, performance of judges, issues of discipline of judges. That cannot be the mandate of the Commission of Administrative Justice. That is clearly the Judicial Service Commission's work.
Okay. I would interject and say that when you look at Article 59 of the Constitution, though the CAJ, Commission on Administrative Justice, is created under an act of statute, but the law proceeds on to say it will have the same status as any other commissions under, I believe, Chapter 15 of the Constitution. So from a legal point of view, I don't think it is inferior. The bigger problem is one of them has a direct constitutional mandate, and which appears to be separate from the other mandate of the other. So where there is convergence in this conflict, that's where the problem arises. Because it's just like we live under what we call the doctrine of separation of power. And for example, they say that if you are parliament, you cannot exercise judicial powers. If you are the judiciary, you cannot exercise legislative power. And so is the executive. So that the president of Kenya cannot, if he hates you however much, he cannot get you arrested and you are taken straight to committee. You will have to go before a court of law, and only a judicial officer can take you to committee. So in the same way, one would expect that if the complaints on the face of it primarily relates to judicial officers, why should it be an issue for the Commission on Administrative Justice? That's where the problem begins.
So, And I think that's perhaps the reason why one has got to read much more. The emergent move of one institution, of incursion into the mandate of another raises serious questions. Because first of all, who filed these 700 complaints with the ombudsperson, over the years? If somebody had a problem with the judge, the Judicial Service Commission is there. We also have a judiciary ombudsperson, by the way. There's also an ombudsperson within the institution of the judiciary. So that if the question or the complaints were not addressed by the JSC, there is still the ombudsperson who would have addressed. Why go to the national ombudsperson over a judicial matter? Why bring the matters of IEBC, for example, if it's an internal IEBC issue, for example, to the judiciary when you have a dispute resolution inbuilt and internal processes? There are serious questions here. I think somebody's overstepping their mandate.
So, do you hold the view that the JSC members should honor the summons or is this a case of someone overstepping from where you sit?
I think the regular manner is when you disagree, because you see if summons have been issued, so that you do not aggravate the conflict and compound it more, you may need to challenge it in court, because if you are saying they do not have the power to do that, then the fair thing, the law says you go to the High Court. But of course that again is not the best of the issues, where you are having two bodies that should be serving the people of Kenya by exercising their distinct constitutional mandate, now having an internal war. It's a civil war, essentially, which cannot be a good thing for the country.
It's to the detriment of Kenyans, of course. Let's just expand this conversation to include the ouster of the 7 Supreme Court judges, because the High Court decision to halt JSC proceedings seeking the ouster of the 7 Supreme Court judges highlights the magnitude of the battle facing these top judges. The petitioners want them axed over alleged incompetence and misconduct in handling various cases. And I'd like to begin on this particular point, because the Supreme Court judges moved to court seeking the suspension of the JSC proceedings on the grounds that, the Commission lacked the constitutional mandate to handle claims against them. What constitutional functions fall under the JSC mandate? Does JSC have the oversight authority over the Supreme Court? I think that's a big question here. What's your take on that?
First, my take would be that the JSC performs many functions when it comes to appointment of judges, but the most critical one is actually the protections of the independence of judges and the judiciary.